Thank you very much for the opportunity. I'd like to welcome the Chief Prosecutor, the Presidents, Vice Presidents, and the invited ambassadors, all of our dear guests who are here from Hungary and beyond, and also our dear colleagues. I used the old and the new criminal code on a number of occasions at this pulpit, so it invokes different memories in me, not just the memory of the conference when I come to this room. It's well known that the first recommendation for the first criminal code was developed by Károly Csemegi in 1872 to 73, and then submitted it to Parliament in 75. It was discussed until 1878, and Károly Csemegi delivered 101 speeches concerning the criminal code. We know it came into force in 1880, and that was the first criminal code of Hungary, which still has effect today and laid the foundation to the dogmatics and principle of the criminal code and criminal law. Despite the fact that this criminal code was developed for years, Károly Csemegi said, finally, no one doubts the truth that whatever right principles we follow when creating a code and whatever the measures might be, the real circumstances can only be considered to be such circumstances that have existed for some time and the rightness of which was proven by results. Well, for the sake of translation, I would say, as it's an archaic text from 140 years ago, so I would say that however carefully people put together an act and however well-founded the exercise is, it's only practice that can prove how such code will be understood and applied in day-to-day practice, and which practice will be favored by the legal practice and which one will be ignored or pushed to the back. And that is also true for the code we apply today, and representatives of the profession and legal scientists have done a lot year by year, including in the past decade, to make the criminal code even more perfect. And as a result, the lawmaker modified certain acts. I, from the aspect of the Constitutional Court, as a member of the Constitutional Court, I'd like to outline some cases and highlight how legal application, the day-to-day application of law by the judges and the prosecutor go hand in hand with the legislative process and the impact of the Constitutional Court, and how, as a result of our day-to-day operation, legal provisions change. We should, as a matter of fact, have a cake here with 10 candles on it, because the new code came into force 10 years ago, and we can say that the cake indeed is sweet and not bitter, because the past few years have proven that the criminal code stood the test of times. As for the Constitutional Court, looking at it from the aspect of the Constitutional Court, in the past 10 years there were 13 material resolutions passed when either MPs submitted a motion or judges did so, or there was a constitutional complaint that put the case in front of the Constitutional Court, and it resulted in the amendment of certain provisions of the criminal code or the norms. I just highlighted some of the norms provisions here that the Constitutional Court dealt with. These are the key provisions. So we have 13 material cases we have dealt with, but there is one legal area where we had at least 13 resolutions passed by the Constitutional Court. We cannot discuss each of them. I'm just highlighting a few. The first one is the second chapter of Article 216 of the Criminal Code. The motion was submitted by an MP, and the essence of the submission was that under Chapter 2 of the Act, if the reporting entity of the case or the person authorized to manage the data commits a crime, then it makes the data inaccessible by the person, and in such cases no criminal procedures will be launched, as it will not be reported to the police. And the justification was that that violates the legal security of the state as set out in Chapter 1. And indeed, the Constitutional Court established that it goes against the fundamental law, and the lawmaker immediately took action and deleted Chapter 2 of the Act, so it cannot be found in the Criminal Code as it is here anymore. The second one is sexual abuse. That was already mentioned by the President, and it's an interesting case for me and for others, because you can see the two-way impact of the application of the law and how those who apply the law and the lawmakers and the constitutional law impact each other. As it's known, there were two judges turning to the Constitutional Court, asking the Constitutional Court to actually make the Section 2 of the Act of 2016 null and void, quoting the fact that partly due to the division of power, so they violated the principle of the division of power. As a matter of fact, it must be established that despite the fact that the Constitutional Court established that the norms are clear, yet, despite the legal unity resolution, it gave room to the point made, because for the appliers of the law, the mode of application wasn't entirely clear. Even despite the fact that the Constitutional Court didn't dispute this issue in terms of the clarity of the norms, yet for those applying the law, it was a kind of ammunition when the court established that the National Assembly has the opportunity to highlight sexual abuse committed against children from the current legal framework and regulate it in a dedicated piece of legislation. And in such cases, the lawmaker can set more proportional consequences, and it doesn't stop the lawmaker from taking into consideration the legal unity resolution that was actually crushed by the Constitutional Court. As a result of the legal unity resolution of the Curia, even though the court made pass the resolution it did, it rolled on because rules against pedophiles were tightened up and certain provisions on the protection of children were also made stricter, and they came in force on the 1st of February 2022. And we are fully aware that the evidencing process is the most valuable part of the process for everyone, including the prosecutor and the judge. But, and here I consider it very important to say it today, that even given the fact that everyone does their best, they still influence each other. And as a result, we have a much more clear-cut legal status defined. The next resolution, which is also a material resolution, is also a resolution that I participated in. It's about the definition of drugs, psychotic drugs. The Act states very clearly what qualifies as a psychotic drug or a psychoactive material. It quotes a number of international agreements and annexes. This is one particular area where my practicing colleagues know exactly that the requirement from consumers is that they should change the status of these designer drugs, because there are new ones emerging on the market every day, which are very difficult to follow and define. However, at the same time, it was included in the Criminal Code as to what qualifies as a psychotic drug, quoting the international agreements, and psychoactive materials. And a judge turned to the Constitutional Court, speaking out against this provision and making the point that by Hungary signing the anti-drug agreements and adopting such agreements, and the anti-drug committee actually convenes every year, so Hungary transposes these agreements, but not in the annexes of these decrees of legal force. So they are actually transposed in different parts of the legislative structure, and in the view of this judge, that violated legal certainty. The Constitutional Court emphasized in its ruling that they can only decide on the lawfulness of this.
A jogalkotó döntési kompetenciájába tartozó kérdés, azonban itt mivel nem
So, because they didn't include a full definition of drugs, and actually the old criminal code didn't even venture to define the concept of psychotic drugs. The next case I'd like to talk about is a case where no material resolution was passed. However, it has strong significance to children. Once again, a judge turned to the Constitutional Court for the following reason. The Czine Code already included the age 12 as the age limit for punishability, and the Criminal Code brought back that age limit for certain types of crime, and as a guarantee it set certain conditions, including the fact that they must have legal capacity and understand the consequences of their actions. And for children of between 12 and 14 it is possible, and it set out the specific types of crimes where legal accountability can be applied.
And in this particular case, the judge turned to the Constitutional Court for the following reasons. There was a perpetrator of the age of 13, and he committed homicide, qualified homicide, along with his accomplices. And the judicial expert opinion concluded that he did have the ability to understand the consequences of his actions, and he has full legal capacity. On the other hand, the person was 13 years of age and he committed homicide, and he had legal capacity and he had an ability to understand the consequences of his action. But there was a psychologist who was involved in the case, and he concluded that as a member of his team, he was not able to understand the consequences of his actions. It was peer pressure and his inclination to obey orders that allowed him and made him to commit the crime. So as a result, he asked that the Constitutional Court should annul the provisions applicable to his case because the person is not punishable. The Constitutional Court also gave a view in retrospect of the development of the law and pointed out that the legislator failed to properly identify what it means to have an understanding of the consequences of one's actions. So eventually it was the chief prosecutor who issued an instruction, and there is also a decree by the Ministry of Justice. And these were the two sources of law having certain provisions in them, but even then, these two failed to properly identify what it means to have an ability to understand consequences. However, the psychologist's opinion indicated that there is a problem, and the judge concerned, who turned to the Constitutional Court, concluded that these two provisions in the Criminal Code were unconstitutional. We need to go back in time, and I mentioned the Czine Code already, which already included punishability above the age of 12. And this Czine Code also failed to properly identify the concept of the ability to understand the consequences of one's actions. At a later point, however, the code mentioned intellectual and emotional maturity. So this was the notion that was used earlier for a definition of what it means to understand consequences. So once again, there was this judge who turned to the Constitutional Court, and he said that this was in violation of paragraph 1 of Article 16 of the fundamental law, which I am displaying in the screen now. And here we read about the right of children to being taken care of and to have an environment in which they can develop. The Constitutional Court failed to investigate this part of the legislation, so therefore it had to assume a position concerning this description of an environment protecting a child under the age of 16. And here they talked about proportionality and necessity. And the question was whether any restriction was necessary. And the conclusion of the Constitutional Court was that the restriction which enables punishability under certain circumstances above the age of 12 is a necessary restriction protecting society. And in terms of proportionality, the position assumed was that this restriction was proportionate, fully proportionate, because it was enacted in the interest of protecting society and also in the interest of protecting the development of children. However, the Constitutional Court contacted the National Center for Research and Development and its Director General with the same question. And the response they received was that at the time there was no guiding principle in effect and there was no methodological letter available, and therefore the Judicial Chamber thought that it was necessary to work out such an instruction. Eventually, the Constitutional Court assumed the position that this request to conclude that the provisions were unconstitutional should be rejected. However, they also further investigated the absence of a proper definition, and they also referred to the the position of the National Research Institute, and therefore they concluded that a possible emotional influence being applicable in the case cannot be excluded, but they further pointed to the need to work out the proper methodology. So I understand that I spent quite a lot of time with explaining this case, but I wanted to illustrate that the new criminal code was intended to achieve a situation in which it is possible to adjudicate cases in a fast and modern and efficient manner, and certain cases were adjudicated, and they all prove the fact that the new criminal code is pointing to the right direction. And I want to conclude by the words of Károly Csemegi, namely that that legislation continues to work incessantly. However, it is always able to make amendments whereby it will be able to achieve the goals which always feature in any developing society, and which need may be very urgent. Thank you very much.